And let's go right to Washington, D.C., where Andrew Ross Sorkin is speaking with FTC Chair Lina and the DOJ's antitrust chief, Jonathan Kanter, at the CNBC CEO Summit in Washington. We'll listen in here.
Dive into what's going on in the antitrust world. I think there's a lot of people in this room and around the country in the business world who think you two, if you can even imagine it, may very well be the most powerful people in the world of business today as it relates to where all of this is going from a regulatory perspective. So I want to start with actually just a very basic philosophical question. Jonathan, and I'll start with you, which is when you think about the idea of what I think is a relatively bipartisan perspective about M&A and mergers and acquisitions and whether they should be evaluated through the context of a consumer welfare standard. Is that the way you think about it? And if not, what are the other component parts to the discussion?
Sure. So I think I'm fond of saying that if you ask 5 antitrust lawyers, what is a consumer welfare standard, you get 6 different answers. So a standard is something that people agree on. And if people can't agree as to what it is, then it is no longer a standard. The purpose of the antitrust laws is to protect competition. Competition leads to better market outcomes and is essential for a market-based economy. Our mission is to protect competition. That might mean competition to the benefit of consumers, might mean competition to the benefit of workers. It might mean competition to the benefit of entrepreneurs who are just starting a new business to innovate and provide new products and services beyond our wildest dreams.
Can you see a transaction or a situation in which you would advocate for more competition, but it would ultimately hurt the consumer?
I'm not aware of any case that either of our agencies have brought where the consumer was worse off as a result of our actions.
Well, you understand why I'm asking the question, because if the consumer welfare standard is not the sort of ultimate benefactor and competition is, how to think about that dynamic.
Let me try to address this. Many transactions are B2B. There are companies that don't sell directly to end consumers. There are companies that might sell to another business. We brought a case involving book publishers where the theory of the case was that the authors, the laborers, would have earned less in terms of advances. And we won our case, and that was a cognizable antitrust harm. There have been antitrust cases involving college athletes. Right. These are important stakeholders in our economy.
So, Chair Khan, I want to ask you about this. Jon Stewart recently interviewed you and asked you on the Daily Show what the metrics of measuring whether there's a monopoly. And part of your answer was this. You said the most direct way is to look at how a company is behaving. What do you mean by that?
First of all, it's really great to be here. And this is a really important question. And it's one that we grapple with day after day. And we want to make sure that the tools we're using to figure out what does competition look like, do we have a monopoly, are actually matching what you all think about, what business leaders think about. And I think one of the problems that both of our agencies have been looking to correct for is the fact that over the last few decades, we'd seen a real gap emerge between how antitrust folks were analyzing markets and how business people were analyzing markets. And so we're trying to bring that closer together, that gap between theory and business reality. There are a whole bunch of ways in antitrust analysis that you can assess if a company is a monopoly. You look at the market share, define the relevant market. To my mind, one of the most probative ways is to look at whether a company is able to make things worse for its customers or its workers and get away with it. Because if you have a functioning, free, competitive market, the idea is that if a company is being abusive towards its customers, those customers can go elsewhere. But if you see a persistent pattern of a company raising prices, degrading service, making it impossible to actually get somebody on the phone, all these big and small ways that the consumer experience is worse, and you don't see defections, similarly, you can see the same thing on the worker side, that can be direct evidence of monopoly power that companies are at a stage where they can make things worse without losing out in the market.
How much do you think about, you bring very specific cases, but a lot of those cases have had what might be described as a deterrent effect for more transactions. Some data for everybody. In 2021, the year the both of you took office, there were $2.79 trillion in deal making in this country. In 2023, there was effectively half of that number, $1.48 trillion. Now, some of that you may want to ascribe to economic forces and other things. But I would imagine if we polled this room, many people would say that they have held off on doing deals or have looked at deals differently as a function of the work that you two are doing. Do you look at that as a success?
So my job is to enforce the laws that Congress has written. And I'm very sympathetic to the idea that, when you go from decades of more lax enforcement to now an approach that is being more rigorous, that can be disorienting for the business community. And that's why our agencies have really taken a lot of care to put out notices, to put out new merger guidelines explaining how we do the analysis. But I do think we were previously living in a regime where there were deals making it out of the boardroom that were facially unlawful. And practically that means that we then have to spend public resources going to court. And so when we see, senior deal makers on your show saying years ago we wouldn't think about antitrust risk until the very end, if at all, and now antitrust risk is part of the conversation on day one, for us as enforcers, that's a really good thing. We want that legal consideration to be part of the analysis because illegal deals should not be pursued.